Yes, good morning. Once again, we thank the Minister of Finance, the Honorable Matia Kasaija, for responding to our summons. The Honorable Minister spent the whole morning trying to put down a statement, and then he ran to attend a funeral service, and then I came back, and that's why we're starting at the time we're starting. Thank you very much. We may proceed.
All right. Thank you, my Lord. Deputy Lead Counsel will be leading the witness.
Much obliged. Honorable Kasaija, kindly stand up so that you may take oath.
I, Matia Kasaija, do hereby solemnly swear that the evidence I'm going to give touching on the matters before this Commission of Inquiry shall be the truth, nothing but the whole truth. So help me God.
Thank you very much, Honorable Minister. Kindly restate your name in full for the record.
My name is Matia Kasaija, Member of Parliament for Buyanja County in Kibale District, Minister of Finance, Planning and Economic Development in the Government of the Republic of Uganda.
Right. How old are you, Mr. Honorable Kasaija?
On the 26th of this month, I will be exactly 74.
Right. And where do you reside?
I reside in Mengo, Mengo Namirembe.
That is Rubaga Division?
That is Rubaga Division.
Kampala?
Kampala.
Right. You have already stated that you are a minister responsible for finance, planning and economic development in the government of Uganda. Do you carry out any other activity to survive?
Yes, I do.
Yes. What is that?
I'm a prominent farmer.
What kind of farming do you
Cattle
do?
growing.
Cattle keeping. Right. How long have you been a minister, the Minister of Finance?
Since 2015, March.
Okay. Maybe this is the time to talk about your academic and professional career background. Can we start with your academic qualifications?
I hold a degree in business administration and from the East African University, Nairobi Constituent College in 1969.
Right. And what about your career background, where you've worked until you became Minister of Finance?
It's a checkered career. I started working for Shell BP in 69 until I had to resign in 77 because I almost lost my life, but that is beside the point. Then I went to private business. Then I was elected as a Member of Parliament. Then it was called the NCC in 1980. Thereafter, I went to war and returned.
Did you say you went to war?
Yes, I did.
Where was that?
Ruero. And other parts of the country and the world. So I came back, and when I came back, I worked at the NRM Secretariat from 1986 up to 1969, 89.
In what capacity?
I was a mobilizer.
Okay.
Secretary for Mobilization.
Right.
Then I was appointed as Executive Director of the Department and Custodian Board up to 1994 when I ran for elections. And then 1980, 20, 20.
So in 1994, when you ran for election, you won?
No, I didn't run. I didn't win. I retired to my farming,
Right.
and I will tell you when I came back again. But
Yes.
in 1998, I was redeployed again in the NRM Secretariat until I was elected as Member of Parliament in 2016. 2006.
2006.
Yeah.
Can you remind us of the constituency?
Buyanja constituency, which I'm still holding up to now.
Right.
Then in 2006, I was made Minister of State in the Ministry of Internal Affairs.
Minister of Internal Affairs?
Yeah,
Okay. That was 2006.
2006.
Okay. And it is from that position that you became Minister responsible for finance?
Yes, I was appointed from Internal Affairs and deployed in the Ministry of Finance as the Minister for State for Planning, first of all.
Okay. So, Honorable Minister,
So when were you Minister of State for Planning?
Sorry.
Were you Minister of State for Planning?
Yes,
Did
I
hear
was.
that?
Yes, my lord, I was.
Right. That was before you became Minister of Finance.
Yes, that's right.
The full minister.
The full minister.
Honorable Minister, as you are aware, this commission was established to investigate many things concerning the land sector. It has terms of reference, and term of reference number 1 is to investigate and inquire into the law, processes, and procedures by which land is administered and registered in Uganda. It was also tasked with investigating into how the Uganda Land Commission administers the land fund, and also to investigate matters incidental to these and the other areas covered in the terms of reference. We must thank you for coming, and for the fact that when we called you, you promptly responded to our summons. You did not claim to be consulting cabinet, your parish priest or your ancestors. We have to thank you for that.
Thank you.
Before we proceed,
I'm an obedient servant of this country,
thank you very much.
and I like to move by law.
Thank you very much. So we are going to today specifically talk about 2 areas which I've mentioned: the land fund and matters to do with the departed Asians' properties custodian board. We will start with the custodian board. Do you know about that board?
Very much so.
Yes. Can you tell us about it? What is...
Before I was made a minister in 2006, as we said, I worked for Custodian board.
In what capacity? Remind us.
Originally, I was nominated by the president, as because the law allows the president to nominate 2 people, and subsequently he deployed me to be his chief executive, right from, as I said, 89 up to 94. I was the executive. They gave me a title, Whether it is in accordance with the law, I don't know, but I was appointed as executive director.
Secretary.
Yeah, the executive secretary.
Yes.
The law secretary of the executive secretary, but the title which was given to me by the appointing authority was executive director.
Okay.
So I ran the show, but I continued as a member of the board right up to the time I was made minister for finance.
Okay.
I continued playing that role.
Okay. So the mandate of this board is well known. Maybe we'll not go into it. But suffices to say that it's an important role because it is tasked with the management of very prime properties in this country. So it is something that the country has got to handle very well, very carefully. Who are the members of the board, this custodian board?
My lord, the board is composed of 7 people, of which 5 are ministers and 2 are nominees by the president. According to Section 4 of the Departed Asian Property Custodian Board, these are the ministers responsible. 1, the Minister for Finance, who is the chairperson, the Minister responsible for Commerce, as a member, Minister responsible for Lands, Minerals, at that time, but now it's the Minister of Lands and Urban Development. The Minister, so the Attorney General, and the Minister responsible for local government, and 2 presidential nominees.
Okay. So you are the chairperson of the board currently?
Currently,
by
yeah.
virtue of this
Yes,
provision of the Act.
correct.
One of the things that have been brought to attention is the fact of allocation of property under the custodian board to various individuals.
Sorry, can I get that again?
Allocation
Allocation.
of properties under the care of the board, contested or not, to various individuals. A few, okay, let me say about a week ago, we had the current executive secretary of the board here, sitting right where you are, and he told us we were investigating a specific case of allocation of 2 or 3 properties.
Can I get clear? Allocation to rent.
Let's just use the word allocation for now.
Okay.
To various, to a certain company. And the question that we posed to him was, where do you derive this authority to temporarily allocate property falling under the board to anybody?
And just before you answer that question, would you like to tell us who you came with? Because I know you've come with an officer next to you. We want to place him on record, or at least to have you say something about him, then you can continue.
Thank you, my lord. I'm sorry, I should have done that from the right to go. Is Wilson. He's my economic advisor.
Does he have a second name?
Yes. Tukamuhabwa. At times I tend to forget that name because it's very long. Tukamuhabwa.
Okay.
Yes.
The economic advisor.
He's my economic advisor.
Okay. Is he a member of staff of the
Custodian board?
Is he, yes.
No, he's a member of staff of the Minister of Finance.
The Minister of Finance. All right. I'm sorry, I should also have actually raised that at the beginning. So the question we raised was, where do you derive this authority to temporarily allocate these assets to anybody? We looked at the law with him. We did not find any provision. Thankfully, you are not just a minister of Finance and therefore the chair of this board, but you have also been in that position before. So you can advise us. Where is this authority derived from?
The executive, my lord, the executive secretary is the chief executive of the business of Custodian board. And him and his team, they do the day-to-day running of the business of the board. The board is wisdom, right for the time when I was in charge in the 90s, as I've said, the issue of allocating properties for rent is an administrative issue, is a daily issue. The question of collecting of rent, we left it to the executive secretary together with his or her team, because we didn't think that was necessary for the board, because this board is a very high-powered board composed of ministers principally. We didn't think that we should really be involved in the question of negotiating rent, allocating a property, cancelling a tenancy in case the tenant is not doing what he's supposed to do as per agreement.
Honourable Minister, just to correct you, the issue is not what authority the board has given to the executive secretary. The issue is whether what is being done is provided for or supported by the law. You know, there was an act in the 1980s, the Expropriated Properties Act. That act recognized that assets had been expropriated and they were to be returned. And that would involve properties being given back to their owners, those that can be found. Those that cannot be found are to be disposed of. The idea was not that the custodian board should be a landlord or an estate agent. So the question is, where did this concept come from? The property should either be returned or disposed of.
No. The board can deal with the properties in 3 ways, particularly the minister in charge of finance. They can keep the property for government. 2, they can return. 3, they can sell. So that's one of the 3 modes of disposal of the properties. And when the property has not yet been dealt in the other 2, either return or sell, then it is government property, and therefore it must be administered. You can't just leave it hanging around. That's why the secretary comes in to allocate temporarily until the minister and the board have disposed of that property.
Okay. So, how is this decision to retain property or to dispose of the property made?
The board decides. If government made a request and say, we want this property here for this, then particularly if that property has already been compensated for, then the government can retain it. It comes from the request of government.
Okay. Government in this case being who?
It should be public. I think in this case it should be public service or Minister of Lands and Housing.
Okay. Let's talk about specific properties. The specific property that we are talking about here. On 12th December 2017, a company called Amobet Investments Limited applied for allocation of the following plots. Plot number 29, Acacia Avenue, Colorado Hill, known as LRV 235, folio 7. Plots 15/17, First Industrial Area, Kampala. Plot 12A, Prince Charles Drive, Kampala, known as LRV 467, folio 21. And lastly, Plot 21, Chadondo, Chibuga Block, 38 Mengo, LRV 7364025. And this is what they said. This was addressed to the executive secretary. Said, this was someone writing on behalf of the company. I said, I write to seek your approval for allocation of the above plots currently under the custody of the departed Asians Property Custodian Board. The plots are to be developed and utilized as follows. Acacia Avenue, Koro will be developed into an ultra-modern office space for rent. 2, industrial area will be developed into a modern furniture showroom. 3, Prince Charles Drive will be developed into a residential building. 4, Mengo Chadondo will be developed into a residential apartments. With time, I hope to purchase these properties in accordance with the legal requirements. The property should be allocated to Amobet Investments Limited. And I thank you for your cooperation. As at 12th December 2017, what were the status of these properties?
I don't think I have that detail, but I can always get it, because if it was a free property, let me use that word, free, in a sense that it had not been repossessed by the previous owner, it had not been sold to any interested party, and that it was within it was now government property, I wouldn't be able to tell you what category it fell in, but I can always find out the details and give them to you.
Okay. You see, under Section 12 of the Departed Asians Property Custodian Board, first of all, the provision envisages that the minister will make an order if government has made a decision to retain a property or a business. The minister responsible for finance shall make an order to that effect. Now the question is, do you recall making any order, or your predecessors making any order for the government to retain these properties?
No, I don't recollect at all that I made an order or that I was in the know-how whether my predecessors did do that. I would not.
So if such an order, let's assume it was never made, and we think it was never made, what would be the basis of the custodian board purporting to be some sort of landlord vis-a-vis these assets? Maybe the question is, why are they still under the custodian board?
I presume, and I'm using the word deliberate, I presume the property, those properties are under the custodian board because they have not been disposed of in the manner that I said earlier on, either by returning them to the previous owners, the Asians, or by selling them to individuals who may have applied to buy them.
Okay. So the question then is, why are they in limbo? You see, they have not been repossessed, they have not been sold, they have not been retained by government because there's no order to that effect. So the question is, why are they in limbo? Why do they lack status?
No. No, let me explain. They are not in limbo. I've told you these properties.
I don't know whether I use the right word anyway.
Yes. Limbo, that they seem to have no owner. No. If they have not been disposed of and given back to the owners, or they have not been sold, they are properties of the government of Uganda under the management of the custodian board.
In your understanding, was this board meant to exist forever?
No, it was not meant to exist forever. Once it had dealt with all the properties, then it would wind up, and actually we are in the process of trying to do so. Then cabinet would take a decision, those properties which have not either been repossessed or have not been sold, how to handle them. Then the government can decide, okay, we give them to either the Minister of Public Service as part of the government property for doing business, by government doing business, or whichever manner the cabinet may decide ultimately to dispose of the properties.
Okay. We have come across cases where the board where the Minister of Finance issues a certificate of repossession in accordance with the law. 5, 10, 15, 20 years, the board turns around and purports to challenge the same certificates, to ignore them, to reject them, to disregard them. To us, that's contrary to the law. Are you aware that that is happening?
I'm not aware where a legitimate certificate has been issued and is being tampered over.
What do you call a legitimate certificate?
Well, legitimate that has been obtained in accordance with the law. Illegal, in fact, maybe let's use illegal.
Assuming it's not, assuming it was not obtained in accordance with the law, what should happen?
Then my thinking that then would go to court to have that certificate cancelled.
Thank you very much. So you are mindful of the fact that it's only the court
that can cancel,
specifically the High Court, that can cancel
a certificate of repossession. Yeah.
Okay, so I'll show you a document here. Maybe if I get the letter, I'll tell you the story. The former owners of plot 29 Acacia Avenue applied for and obtained the certificate of repossession in 1992. Everyone was happy until last year, when your executive secretary wrote a letter to a company called Amobet Investments Limited, purporting to temporarily allocate the property to that company. A lot of things have happened since. My question, Honorable Minister, is, given what you've just said, what is the value of this letter? What is its legality?
If there is a standing...
You can take a look at the letter. Let's not assume that you have all these facts. Can you just for the record go through that letter, Honorable Minister?
Yes, I'm going through it. You want me to read it?
Yes, yes.
This letter dated 14th December 2017, addressed to Amobet Investment Limited, PO Box 2427, Katonga Drive, Ntinda, Kampala. Dear Sir, dear Madam, temporary allocation of the property on plot 29 Acacia Avenue, Kororo Hill, RRV 2354007, Kampala. Reference is made to your letter dated 12th of December regarding the above-mentioned subject. This to inform you that the above-mentioned premises have been located to you with effect from 14th December 2017 on temporary terms and upon the following conditions. 1. To pay rent of 550,000 per month payable in advance. Not to sublet or part with possession of the property or any part thereof. 3. Since this is a temporary allocation, you are advised not to make any major developments on the property, as this office does not accept any liability whatsoever for compensation in respect of any development effected. This allocation shall be terminated in the case of breach of any of the conditions stipulated herein. If you accept this offer upon the terms and conditions stipulated above, please communicate your acceptance within 7 days from the date of this letter. Yours faithfully signed by Mr. George William, Executive Secretary of Department Asian Property Custodian Board, copy to me, compared to the RDC Central Division, and compared to Town Clerk Central Division, and compared to the DPC Central Division.
Did you receive your copy?
I need to check. I may have received. I received so many of these, so I need to check.
But at least you are sure you didn't react to it?
No, I did not
You
react
did
to it
not.
for sure. I did not.
Was that because, Honorable Minister, you thought that was a proper and lawful letter?
Well, assuming, because some of the things really I have to assume, this is a senior person.
We'll come to that question, Honorable Minister, of Mr. Abizu being a senior person. But let's just talk about the letter.
No, the letter, if the property is in the hands of government, it does not, it's not owned by anybody else, then this is appropriate.
Did you preside over a meeting of the board where that property and what should happen to it was discussed?
No.
So this was Mr. Bizibu's?
It was Mr. Bizibu who initiated to allocate. So
and I think a while ago you seemed to say that is in order that one person called the executive secretary, I like the word executive, I don't mean to not recognize the importance of that word, but that person should sit alone and take decisions as fundamental as that without the knowledge of the board.
Yeah, I've told you the question of renting, the problem they're using the words here, but the real word is renting. Allocation is renting.
Mr. That letter is not as innocuous as it seems. Remember, it's responding to an earlier letter by Amobit, which says, let me go in, I'm just paraphrasing, let me go in, and when the time comes to buy, I'll be there. So what that man is doing, Mr. Bizu, responding to that letter and they're saying, you can go in, he's triggering a very big and important process. So it's not just the renting, it is something else.
Well, I can't read the motive behind.
No, the motive is clear in the letter. You don't have to read it.
No, if the property, as I said, is in the hands of government, renting it out is no crime, as far as I'm concerned. Renting it out or allocating.
Maybe it's not a crime, Honorable Minister, but since the renting out is meant to be just the first step towards disposal, is it something that should be done by a single person?
Can I correct you there?
Yes.
No, being allocated to rent. This is the word, my lord, the word here allocation really is meaning rent. It's renting. Does not necessarily mean that the current occupant will be given sole. No. When we come to dispose in terms of selling, the only thing that happens is that person who is renting and has been looking after the property very well is given the first chance. And even when we advertise, he or she gets an additional mark, particularly if he has been looking for, this is the policy that I found around. If he's been looking after the property, has been paying rent, he's a good tenant, so he's given the first priority to buy.
Well, that's your interpretation, Honorable Minister. I might have a different one. Remember the letter, the application letter was made on 12th December 2017. The temporary allocation was made on 14th December, just
2 days.
Are they 48 hours? Yes. Later. And Honorable Minister, you don't see anything wrong with this kind of, you don't read into this transaction and see that this is just one of those that we have come across. These are not just renting out arrangements. These are schemes to acquire property on the cheap. First of all, Honorable Minister, Do you really believe that anybody can rent any structure, even if it's a shack in Kololo, at 500,000 shillings in this country, in this town?
I disagree with this figure. In fact, now you have reminded me, either this or another property, I minuted back to my executive secretary, said, how would you determine this rent? Surely 550,000 shillings. And how do you determine the rent? I queried that. I queried that letter. Either this one or other letters. Certainly that figure is normally absurd in my view. You can't, I don't know the property myself, but as you rightly say, whether it is a one-bedroom little house or something in a place like a Kororo, or this is in Kororo or Bugoro? Kororo. You can't definitely rent it out at 500,000 shillings.
Just for information, the owners of that property have been renting that property out at $9,000 a month. Okay. Now, Honorable Minister, the elephant in the room is the fact that that property had already been repossessed. And Mr. Bizibu sits in his glorious office at plot something, is it Apollo Kagwa Road, and purports to allocate that property to someone else. Are you aware that this is happening in your board? That properties previously repossessed are now being reallocated, temporarily allocated to some people by the executive secretary or the board for that matter, and that this is leading to a lot of issues, conflicts, disputes, litigations. Are you aware? As Haji Naduli would ask, are you aware?
I am not aware that the issue is as rampant as you are putting it.
It doesn't have to be rampant, Honorable Minister. It's happening. We have one example here, but we have many, where on the 16th day of November 1992, a repossession certificate was issued in favor of Mandakin Manubai Patel and Sarojben Jantilal Patel. And in over the same property, the property we've been talking about, Plot 29 Acacia Avenue. And in December 2017, the Custodian Board proposed to allocate this property to someone else.
Well, assuming that the repossession was lawful and legal, then what has been done is irregular.
Okay. The executive secretary sat in that chair days ago and claimed that the repossession certificate was never picked.
Was never what?
Was never picked from your offices there. And now from what you say, that's when you were the executive secretary, because that was 1992. And that to him, that means the property was never repossessed. What is your opinion about that? But in the meantime, the people that the people that received the property, that repossessed the property, had their names re-entered
on the title.
On the title, as far back as 1995. They have been occupation of the property, they have been renting it out, they have been earning from it. But someone says, no, you never repossessed that property. So it's available for government to allocate, to rent out. What do you think of that?
Can I ask a question? How does somebody get his name registered back on the title when he's not holding a certificate? Because the law says the repossessor must go to the Minister of Lands, the department responsible for titles, have his certificate of repossession registered, and then now the property reverts back to him or her.
I'll give you the answer shortly. This is the answer, Honorable Minister.
Mhm.
That's the letter from the board to the Minister of Lands. If you could, just for the record, read it out.
Office of the Minister of Finance Verification Committee, PO Box 579 Kampala, and the letter is dated November 27th, 1992. The Chief Register of Titles, Minister of Lands, Housing and Urban Development, Kampala, repossession of property by the former owners. The under-mentioned property has been repossessed by the former owners as per Section 4 and 5 of the Expropriated Properties Act 1982. Certificate number 1299, property plot 9 Acacia Avenue, 29 Acacia Avenue, Kololo Hill, Kampala, and RV 235 folio 14, and to whom the property has been returned, Mr. Mandakini Manubai Patel and Sorjoben Jantlar Patel as tenants in common in equal shares. You may proceed to register the property as per Section 6A of the Expropriated Property Act 1982. I'm enclosing herewith an advance copy of a certificate authorizing repossession in respect of the above property for your identification. Signed by Batemieto is for the acting executive secretary. And then it's copied to the former owners, and the second it is copied to the property file.
So, there you have the answer, Honorable Minister. Your own board, at that point, got a copy of the repossession certificate and forwarded it to the land office, the register of titles, copied in the owner. From that moment, the owner and the register of titles knew about the repossession, and on the basis of that, a change was made in the register. That was it. So when someone turns around in 2017 and says, no, you never repossessed this property because the original repossession certificate remained with us, so there was no repossession, in fact, you're a fraudster. How do you view such people?
I hold a contrary view. In accordance with the law, it's not this one that makes a repossessor to have his or her name registered. It must be the certificate of repossession.
Let me ask a question, Honorable Minister, since you were once Executive Secretary.
Yes.
Whenever you issued a certificate of repossession, how many copies would you generate?
There are two, the original and the one that is retained.
So as far as the register of titles is concerned, does it matter? Especially where your very office, I'm using the word you are, because has written to say that man has been granted a repossession of the property. Go ahead and register him. And forwards the letter and also attaches the certificate of title of repossession. Why would that be a problem? Maybe I should ask in this way. You certainly are married.
With quite a number of children.
Absolutely.
And grandchildren too.
What makes the marriage a marriage? Is it that piece of paper or the fact that you people actually, every indication is that you are married?
Yes, but in accordance with the law.
Yes.
And I'm telling you, my Lord, To me, this was absolutely irregular. You don't have to give someone a letter to say, now go and get registered. You need to give that individual his certificate of repossession. So, I would even take exception on the office of the land, the office of land registration, to have acted on this letter. It's absolutely wrong, it's absolutely illegal. You cannot act on this letter according to law except by certificate of repossession.
Can you take me to that law if you have a copy of that law and we read it together? But Minister, just to be clear, that letter was forwarding a copy of the certificate of repossession. It was not just, they did not just act on the letter. They acted on the letter accompanied by a copy of the repossession certificate. So unless you are questioning the... Right.
I'm questioning the intention behind this. Because I've told you, I don't have my particular...
Have you read the last paragraph of that letter before the signature?
The law?
The last paragraph of the letter you're holding in your hands. The letter that is...
this one here?
Yes, the last
paragraph. The last paragraph?
Yes, what does it say?
I am enclosing herewith an advance copy of a certificate authorizing repossession. There's no advance part. There should be no advance certificate. A certificate is a certificate.
Now let me show you.
No, sir. Let me... We all have gone through universities, and that's where we have got degrees. I told you I got my degree in 1969.
Yes.
Can you give me, you can say, you can, what do you call it, a transcript. But you cannot call it a certificate in advance. You can say, we recognize that Kasaija has been studying a course like this, and therefore, anybody who may be interested in him for employment, please, the degree is coming. But for a property that you send a letter to say that I'm giving you an advance certificate authorizing repossession, this letter, I must submit this
just
letter.
Before you finish, the commissioner has a question.
Yes.
Thank you, my lord. Are you saying that there was no certificate of repossession issued with regard to this particular property at the time an entry was made on the register?
I will. If I go by this, as far as I'm concerned, there was no certificate of repossession issued.
Because the evidence we have on record is that the certificate was not collected. And my question to you is, first of all, you and I agree that a certificate of repossession is a status indicator of transfer of ownership from the government to the person who is issued that certificate of repossession. So which therefore means the moment the certificate is issued, status of ownership changes, government statutory ownership ceases, ownership goes to the former Asian that has repossessed their property. So whether that certificate is collected or not, technically, legally, statutory ownership of government ceases the moment it is issued. So in short, if we agree that the certificate had been issued and not collected, the fact remains that this property was not available for the custodian board or the Minister of Finance to transact in, since they had ceased being the statutory owners.
Well, as I said, I'm not an expert at law. When does ownership in land transfer? Does it transfer at the time I make an agreement with the one who has sold me the land, or the ownership transfers when my name is registered on the title?
No, my lord, if I may come in here, I think we are dealing with a very peculiar area of the law. And when we look at the expropriated properties laws, the fact remains that there are quite a number of decisions from our courts of law. Before an Asian gets a repossession certificate, they cannot transact in this property because it is still the statutory property of government. And of course, there are other general legal arguments about your name being entered on the title, but still there is clear case law in this area, such as the case of Makerere Properties Limited, where if we are dealing with expropriated properties, we cannot fully apply the principles that apply under the Registration of Titles Act to that property. Paramount importance are the expropriated properties laws. So if this certificate had been issued, statutory ownership of government ceased, and they had a right to be entered on the register.
And another thing, I'm looking at a copy of the title.
Yes, my lord.
I'm looking at the Certificate of Title, Leasehold Register, Volume 235, Folio 14. And the entry of instrument number 274,360, registered 4th of October 1995, states that Mandakin Manubai Patel, and then there's a cancellation and signature, tenants in common in equal shares, issued certificate authorizing repossession, number 1299. I don't know whether you have your certificate there and whether this is the same number. Do you have your certificate? Is that the same number?
Yes, let me see. Certificate authorizing repossession.
Yes.
The number of the certificate is, where is the number? The number of the certificate should be, where is the number of the certificate?
I don't see the number written on here anyway.
I don't see the number of the
I
certificate.
don't,
Because
but
these
it is-
certificates, my lord, are numbered. That's how we
Yes.
keep track of them.
Can I give you a clearer copy?
Yes, please. The one showing me a number of
Yes.
the certificate.
It has a number.
It's up there. Yeah.
1299.
1299.
And when is it dated?
Dated,
Just
dated 16th November
1992.
1992.
Yes, under Section 4 and 5 of the Expropriated Properties Act 1982. Is that right?
Yes.
Now, that entry of that certificate authorizing repossession is entered on the title. So I think we should lay that question to rest. That even the registrar at that time noted that there was a certificate authorizing repossession, for leave alone letters and whatever else was flying by. The entry on the register was based on a certificate authorizing repossession.
Absolutely, my lord, I agree with you entirely. If this owner walked into the registry, the land registry, and say, here I am, for sure. But the way I got it from the council there is saying the registrar acted on a letter, which was forwarding, saying we are now giving an advance.
I don't know what kind of people that Departed Agents Property Custodian Board employs, but I think even currently the writing levels are quite confusing. I think they even get worse with the times.
Our apologies, my lord, our apologies for the deficient officers.
Honourable Minister, I think the point has been made. By the time the entry was made, there was a certificate of title.
And actually, when you
No,
go,
it's
they
certificate of
say,
repossession.
yes, when you go
sorry,
on the
repossession?
original, yes, when you go to Minister of Lands and look for that certificate, for the title, you will find a copy of the certificate authorizing repossession in the file. you will find a copy.
The certificate of repossession existed as a matter of fact, regardless of where it was lying. You know, you die when you breathe your last, not when the body is collected from the morgue. So the right of the government to transact in this property ended the day the late Manja Kanji signed on that certificate. So let's move on.
But before we move on, I just want my Lord to get it clear so that we don't make similar mistakes in the future. To my recollection, the law, which unfortunately I must admit I don't have here, but I can go and look it up. The law says that somebody to have his name registered
Which law are you?
There is a law, you know, there are several laws on this property custodian board. I will check it if you can allow me, my Lord.
You would like to come back?
Yes, I will come back. Says that you can only have your name re-registered on the title with a certificate of repossession. Now, from here, if the registrar, the register of titles, moved in accordance with this letter, then I'm saying this is regular as far as I'm concerned.
Well, but that's not what the registry of the title.
He quoted the certificate,
yes.
By the certificate of repossession.
Yes. And in fact, I don't know why you construe that letter differently, but my view is apart from the differences in English, the last paragraph of that letter is very clear, that he's accompanying a certificate authorizing repossession, that letter is accompanied with. And when he writes that letter, he actually puts, he says an advance copy, but actually what he does, the word advance can be construed in many ways, but the word certificate authorizing repossession is actually capitalized. Every word of certificate authorizing repossession is capitalized in that letter, which means this person was writing, saying, I'm writing to you, this is what has happened, and in fact there is a certificate authorizing repossession. And when you go to the Minister of Lands, and unless something has changed in the last month or two, that the title rests together with a copy of the certificate of repossession.
Honorable Minister, assuming that letter from the Custodian Board was irregular, assuming, because I don't think it is, but assuming it was irregular, would it be proper to visit an internal irregularity on a third party?
Well, you lawyers talk about ignorance of the law is no defense. In my view, if the law says you must go to the land registry with your certificate of title, the certificate of repossession, and here we are talking of, I don't know what this means, certificate of possession of, in respect, an advance copy. If I had been the one pursuing this property as my property, I would have insisted, unless he was ignorant of the law, I would have insisted that you must give me my certificate and I go with it.
Well, since that one involves many issues according to you, which are legal otherwise, let us go with the writing as it is.
And the Commissioner is going to ask you another question. But I think the way you're interpreting these things is very worrying. Because if today you're the Minister of Finance, Economic Development and Planning, and your view is that if you find an irregularity, you visit it upon the tenant, that is very dangerous for the property, because that means that you're going to revisit issues that are actually settled. And just for the history of it, the persons who, the proprietors of this property, one of the proprietors, the first proprietor of this property, has been the proprietor since 1968. Came back, repossessed 50% of her shares. the 50% of the shares were sold by the co-proprietor to a nephew since 1992. So the two have now continued. 1992, this is 2018. If today the Minister of Finance wakes up and decides that no, this property was never repossessed, if that attitude is true, then it's very worrying for the rest of the properties, because that means we can't have settled repossession. And actually it can cause, I think, a bit of a, not a bit, but quite an upheaval in this property, in this area. Because if we are going to start reconstructing what's going on in those buildings, when some of it is actually quite settled, I think it is very worrying. But Commissioner had something.
Thank you, my Lord. My Lord, the Honourable Minister seems to suggest that a former owner had to walk to the registrar with a certificate authorizing repossession. I think the section you've been talking about that you didn't remember is Section 7 of the Expropriated Properties Act, which is about transfer of title, and it reads, a certificate issued under Section 5 or 6 shall be sufficient authority for 1, the Chief Registrar of Titles to transfer title to the new joint venture company or to the former owner as the case may be. So when you look at Section 5, it talks about property in which government is interested, and Section 6 talks about that property in which government is not interested and is transferred to the former owner. So my understanding of this section is that the law did not envisage someone walking with the certificate to the registry. Ideally, on issuance of a certificate of repossession, the person issuing it would actually write a letter to the chief registrar, attach the certificate of repossession, and then the registrar would act on that and make the entry on the register that from this day onwards, this property has been transferred to the former owner. That would be the ideal. So which therefore means that we cannot fault somebody who did not walk into the chief registrar's office with the certificate of repossession under this section. The moment the certificate is there, anyone can move the chief registrar to enter those changes on the register. So on the basis of this letter, even without the former owners walking there, the registrar under Section 7 would make the entry and it would remain a valid entry in law.
My Lord, if we proceed like that, I see a problem. You know, human beings, you know. Someone will go and issue a certificate of repossession or purchase, whatever. Then would even employ maybe an attorney, and then with this kind of letter, he walks in the office of the registrar of titles, or forwards the letter, this letter, forwards this to the registry. We would have many problems, I can tell you that. That's why the law somewhere, you can help me, it is emphasizing that those who want to repossess their property must return to Uganda. What does that mean? That means he comes or she comes, is identified, certified, and then is given his certificate of repossession by the minister.
And Honorable Minister,
yes,
I think the facts I put to you were that these people physically returned. They physically went through the process.
Correct.
Then they were registered on the title. So what is the problem?
No, the problem is her argument that the Custodian board can issue a certificate of repossession and maybe attach a letter and send it to the registry without the individual going there himself. I said danger. Fraudulent, maybe I will state it at another. I don't think that an appropriate time. The problems that we are really having in this
Honorable Minister, what do you know about Mr. Watemeto that we know nothing about? Maybe you have some history there and you want to share it.
Well, I heard about him, but I did not know. But no, what I'm saying, I'm not talking about Watemeto or Bizibu or Kasaija one time who was working there. Me, I'm working that if we adopt a system whereby somebody would sit in the office and issue a certificate of repossession and then write a letter like this and forward it to the register of titles without the individual himself being present there, then we can get a lot of forgeries. That's the only point I'm saying.
Now, what is the worst evil? Is the worst evil dispossessing a person who has shown you unequivocally that they have been the owners of this building since 1968 and are the ones who repossessed it currently and are in the building? Is that a worse evil than a person who wakes up today and starts claiming that that building was never repossessed and says, because of my apparent allocation, even if it's temporary, get out of the house? What is the worst evil?
No, I think it's wrong to tell that person to get out of the house. The best thing would be maybe to regularize. If I was running the show, regularize. But to go and dispossess him or her, I think definitely is not right.
What would amount to regularization? What form would regularization take in this case?
In this case would be for the property owner now
to come and pick
his certificate. Because then that is leak proof.
The one thing that the Honorable Commissioner was trying to really emphasize that this is a legal concept here. When does repossession take place? Repossession takes place when the certificate is issued. The collection and other things, these are administrative things. You know, the marriage takes place when you say I do, and the rings are exchanged, and the marriage is broadcast on Book at the TV. Even if the priest retained the certificate that evening, surely the bride and groom should consummate that marriage that evening. You can't turn around and say, no, they didn't collect the thing, so they can't move. So there is a concept there. The concept is repossession takes place the moment the certificate is issued. Collection is another thing.
And if collection was vital to repossession, then it would have been in the law. But I think the Commissioner read the law very clearly. Because the law is that a certificate issued under 5 and 6 shall be sufficient authority for the Chief Registrar of Titles to transfer the title to the new joint venture company or former owner, as the case may be. The law does not include
the picking and presenting the certificate to the register of title. If that was
supposed to be, then it would have been in the law.
Honourable Minister, I think what we learn from this is that you as chairman of the board, you need to take these matters seriously. A lot is happening. Some stories may be sold to you, but a lot is happening and you need to pay a lot of attention to what is happening in the board.
I will.
I'll take you to the next property. Or it is called Property 18, Plot 18, Perryman Gardens, FRV 61, Folio 23, Kampala. This property was allocated temporarily. Now let me start with the repossession. It was repossessed on 8th November 1994, and the certificate of repossession was issued, and I think it was even collected. You may wish to look at it. Can you read it just for the record?
The problem that oh yeah, certificate number 23.
In case it's difficult, your economic advisor can read if his eyes are better.
No. I can see, madam. I can still see. Certificate number 2320. Certificate of authorizing repossession under the law in excess of the powers conferred upon the minister by section 4 and 5 of the Act, and after being satisfied with the merits of the application of Mr. Hassanali Gulam Hussein Baru to repossess the property on plot 18 Permanent Gardens, Kampala, being part of the land comprised in Crown Grant number 20. Is hereby issued subject to the provision of section 8 part 1D of the Act, authorizing the said applicant to repossess the said property, and was signed by of November 1994.
Okay. Do you doubt anything about that certificate? It's a photocopy, yes, but would you doubt anything about the contents, the form, the signatures, the particulars? It speaks for itself.
Absolutely.
Right. Now,
the only thing I cannot authenticate is the signature, of the late minister.
Now, on 11th June 2014, this is what happens. That document on top. Let's start from the date.
Dated the 11th of June 2014, and the letter is written to Mr. Abomugisha Peter, PO Box 3062 Kampala. Yes, sir. Temporary allocation of the property on plot 18 Permanent Gardens, RRV 614023 Kampala. Reference is made to your letter dated 6 June 2014 regarding the above mentioned subject. This is to inform you that the above mentioned premises have been allocated to you with effect from the 11th of June 2014 on temporary terms and upon the following conditions. The rent 300,000 shillings per month payable in advance, not sublet or part with possession of the property or any part thereof. 3, since this is a temporary allocation, you are advised not to make any major developments in the property, as this office does not accept any liability whatsoever for compensation in respect of any development effected. This allocation shall be terminated in case of breach of any conditions stipulated therein. If you accept this offer upon the terms and conditions stipulated above, please indicate your acceptance within 7 days from the date of this letter. Signed by Mr. Mare, Chairman Diversity Committee, also the Acting Executive Secretary.
Same content, same format, same terms. And again, you have property in Kampala, commercial property being allocated to someone to pay 300,000 shillings per month. So there is a certificate of repossession many years ago issued, 1994, and now in 2014, Malay is purporting to allocate that property to someone else. Let's continue. I'll show you what transpires next. Unfortunately, those are the only copies that I have. So
you want me to go to the next page?
No, I'll have to show you which one to look at. So, Abumugisha received this property And then in 2017, something happens. There is a new sheriff in town called George William Bizibu. This is what he's saying.
24th of July 2017, again to Mr. Abom Gishapita. I think that one also Abom Gishapita. Plot 18, Permanent Gardens, LRV 61, folio 23, Kampala. Please refer to our letter dated that one, dated 2nd January 2017 regarding the above mentioned subject. This to inform you that the above mentioned allocation is hereby cancelled since you have failed to clear the outstanding rental dates. You are advised to remove your properties, merchandise immediately. Signed by George William Bizibu.
Have you noted the date?
Yes, 14th July.
14th July.
24th
July
last year.
2017.
Yes.
Let me show you something else. So, the landlord is exercising his, landlord in courts, his powers, and so I hope you've taken note of the date of this purported cancellation. But anyway, how do you cancel something that doesn't exist? And then look at this. And also take note of the date.
Amabet Investments Limited, 28th July 2017, one day after the Executive Secretary, Department of Asian Property Custodian Board, PO Box that application for purchase for plot 18 Permanent Gardens, LRV 61 folio 23, Kampala. I've been running a women's and youth economic empowering business in Bakuri for the last 7 years. Our major mission is to create employment for women and youth through offering them space for training on income generating income. I think he meant it on income generating something. He has put around the word income. We are running a training and tailoring salon and beauty care, fashion and design, electrical, plumbing and carpentry and joinery. I am glad that His Excellency the President has been promoting this venture around Kampala.
As usual, they had to bring in his name.
To support our activity, we are planning to open a training center and showroom for the products of our students. The purpose of this letter is to request you for donation of the above property or in the alternative to offer us to purchase by private treaty. Signed by Namoviru Susan, Program Manager.
Okay. I'm sorry I have to get them back, but we'll have to find a way of dealing with this. So a day later, by some miracle, or when Bizibu proposed to cancel or cancels the allocation,
which he gave to Abom Gishapita.
Yes, and then the following day, by some luck, some miracle, Amabet is at Bizibu's door to apply for the same property. Mark you, Honorable Minister, the majority owner of Amabet Investments Limited is a member of the Custodian Board. That is the Honorable Minister of Lands, Housing and Urban Development. The only conclusion one can make is that these things are not happening just by stroke of luck, by chance. There's something going on. And if you look ahead, maybe your assistant can help you. There is a letter on the departed Asian Property Custodian Board dated 4th August 2017. Have you seen it? A few hours later. Maybe I should give you this. Please, help me. You may return that one.
I have it.
You've seen it?
My lord, I have it. The one dated the 4th of August.
Yes. Can we read it together?
For sure. Now this is now to Amubet Investment Limited. It's a temporary allocation of the same property which we had allocated to Yomgisha. And the rent is 400,000 shillings per month. The contents is the same. I have noted my lord this.
And it is signed by
George William Bizibu,
Executive Secretary. Right. So, just like that, Amobet is a proud occupant of that property as of that date. Do you know what happens next? On On 11th April 2018,
I have the copy here, yes, my lord.
So the Amobet Investments Limited now writes to the Executive Secretary of the board. What is the director saying? There are two actually.
The letter is dated Amobet Investment Limited, dated 11th April 2018. The Executive Secretary, Department of Property Custodian Board, relinquishing our interest in plot number 18 Permanent Gardens in favor of Mr. Peter Abomgisha of P.O. Box 3062 Kampala. We purchased the above property from the Department of Property Custodian Board and complete the full payment, now awaiting a purchase certificate for transfer of our interest. However, we have entered into a joint venture to develop the property in Dubai, which will require additional funds. We have therefore sold our interest to Mr. Peter Abomugisha of the above address. The purpose of this is to authorize you to issue all other documents and a title in the names of Mr. Peter Abomugisha.
Yes.
Signed, Amonji Betty, Director Shareholder, then Adon Ketty, Director Shareholder.
Right. So, upon being allocated the property temporarily on 4th August 2017, on 20th December 2017, the property was sold to Amobet. Do you have a copy of? Do you have a copy of the letter dated 20th December 2017?
Yeah.
Can we read it together?
It's written to Amobet Investment Limited, P.O. Box 23465. Dear Sir, Madam, plot 18 Permanent Gardens, same property we are talking about. At its 12th meeting under minute 14, Department for minute 14, Department the Asian Property Custodian Board, stroke 2017, the board approved the sale of the above property to you at the value put by the chief government valuer, 200 million shillings. Therefore, this communication serves to inform you that within 7 working days of receipt of the same, you are required to pay 10% of the property value, and within 30 days thereafter, you must and they put in capital letters, you must have completed the whole total sum. Failure to comply, you will have forfeited the 10% deposit, and the property shall revert to the Repatriation Custodian Board unconditionally. You are therefore allowed to deposit your payment, leveled payment for purchase of plot 18 Permanent Gardens, FRV 164023, Kampala, on a collection account, that Bank of Uganda. Signed by Mr.
Right.
Fani.
So, on 20th December, the property is relinquished to this person, subject to them paying money. And on 11th April 2018, the same people are now selling the property back to Mr. Abomujisha. Do you smell anything in this, Honorable Minister?
First, certainly there is some game which I can't explain myself.
Involving who and who?
Well, involving my executive secretary, and of course also it must be touching my honorable colleague, particularly as she has declared interest in this property.
Who is that colleague, Honorable Minister?
And that is Honorable Betty Amongin, Minister for Lands. That's how I would read it.
How do you describe that game? What is it? Is it soccer? Is it golf? What is it?
I don't know what I should call it really, but it's an straight game. Okay. Instead of going through the right channel and applying without playing games,
there is fraud going on here. Now, before I go to the next point, the question is, did you, because this letter by Mr. is quoting a decision of the board under minute 14 DAPCB/2017, where the sale of this property to Amobet was approved. The question is, did you chair this meeting?
I would have to look at the minutes. I don't know whether I chaired it or not, unless somebody has got a copy of the minutes. I cannot say I chaired it or I did not chair it.
Considering that a colleague, a cabinet colleague, who actually I imagine, was part of that meeting, was involved, this should have struck you. This is something we should be able to remember. Do you recall in that meeting, or in any meeting around this time, in December 2017, chairing a meeting where the Honorable Minister of Lands and Urban Housing and Urban Development was present?
I can't remember. My
do you recall her ever declaring a conflict of interest in any matter, in any meeting that you've chaired?
No.
She has never?
No.
She sits and keeps quiet and makes the decisions. Right. Now, when this fraudulent sale happens, the owners of the property, or people acting on behalf, persons acting on behalf of the people that repossessed the property, I gave you the certificate of repossession which you read out, they write to you, sir. I have a copy of the letter.
Yeah, they wrote to me. I don't see the date. And the letter, on 14th February 2018. Temporary allocation of plot for 18 Paramount Gardens, FRV 614023 Kampala. I'm the lawful attorney of the registered proprietor of plot 18 Paramount Gardens and address you as follows. I'm in receipt of a letter from the Repatriation Property Custodian Board wherein the subject property was allocated to Mrs. Amubet Investment Limited or PO Box 34, no, 23, 46, 5 Kampala. The captioned property was repossessed and the certificate of repossession number 2320 was issued to Hassanali Wilhamsen Balu on the 8th of November 1994, contrary to allegation made in the purported letter of allocation attached here too that the said property was never repossessed. As the lawful attorney and on behalf of the registered proprietor, we take strong exception at this scheme of fraud designed to interfere with the proprietary interests of lawful owners. I have suffered much similar fraudulent schemes on plot 37 Martin Road, Ode Kampala, plot 19 Bwana Michel Lane Mbale, plot 2 Kampala Hill, 36 Republic Street Mbale, 54 Gabula Street Jinja, where allocations are made by the departed Asian Property Custodian Board in respect of already repossessed properties, leading to the illegal and unlawful interference of quiet enjoyment of property by lawful owners. It is the position of the law as stated by court in case of Moham Sisi Chiwanuka versus Asha Chad, Civil Appeal number 14 of 2002, that only a court can cancel or nullify a duly I think there's something missing.
Really
here.
something missing. Just go to what you have.
Okay. I sought assistance of the Executive Secretary of the Departed Asian in respect of plot number 19, Bwana Michel Lane Mbale, but did not receive any response or assistance. Attached here too is the correspondence in regard to the said plot number 19, Bwana Michel. In all the aforementioned already repossessed properties wherein the Departed Asian Property Custodian Board has made adverse, illegal, unlawful, and fraudulent allocation, the lawful owners have lost colossal amounts of rental income despite continuing to pay applicable taxes to the government. I hereby seek your indulgence in investigating this allocation of plot 18 Permanent Gardens to Mrs. Emobet Investment Limited by the Departed Asian Property Custodian Board, and by copy hereof invite the CID of the Uganda Police Force to look into all these fraudulent schemes, and is signed yours faithfully, Mohammed Alibai, the attorney. Copied to the IGP, the Honorable Attorney General, the British High Commissioner, Chairman Indian High Association, RD Central Division, Town Clerk, Central Division, Area LC1 Chairperson, DPC of the Kampala, Executive Secretary, Departed Asian Property Custodian Board.
Okay. There is evidence that that letter was received.
It was for sure, because I can see Office of the Minister, it was received on the 19th February 2018.
Everything is seen except your reply.
Yeah.
Did you reply to that letter? Did you act on that letter?
I don't recollect whether I did reply. Again, I will need to go and check. Normally, when I receive a letter like this,
I can volunteer information for you, to you, Honorable Minister. You did not act on that letter. You did not reply to that letter. Had you replied it, the complainant would not be here.
now, normally, first of all, he misspelled my name, but that's beside the point. Normally, it may have been received by my office, but I'm not sure whether I cited it. Because my way of doing things, when I receive this letter and I'm referring it to somebody, I will write. I could have written, say, Secretary, Treasury, PS, please do this, do this. I don't see any scribbling of my writer.
What we could say for now is that nothing has been done.
Nothing. Well, as far as I'm concerned,
this man has been left to the wolves up to now. The wolves being Mr. Bizibu, the Honorable Minister. I don't know whether I can use the word honorable and wolves in the same sentence, of Lands, Housing and Urban Development, and others, I don't know, I may not, but at least on the basis of the records. Amobet Investments Limited, a company owned and operated by the Honorable Minister of Lands and Housing and Urban Development, a member of the Custodian Board, your officer, the Executive Secretary of the Custodian Board, at least those two, on the basis of the paper trail. This man is at their mercy. But he has taken the trouble to write to you personally, not just as the boss of that ministry, but also in your capacity as the chairman of the board. And nothing has happened. This is May 2018, nothing has been done. But what that does is to highlight the fact that there's a problem, Honorable Minister. And now you understand why this commission is concerned about this business of allocations.
And what?
Allocations, temporary allocations, and all that goes with that. What would you do, I mean, if you were to act on that letter now?
Well, first of all, I will need to look at the file to confirm that the
No, Honourable Minister, on the basis of what you have now, of course you can always do your studies and investigations. There is a copy of a certificate of repossession. Let's assume it is 100% genuine. You have those letters that you've seen flying around. And now you have that appeal. If you had 10 minutes to act, what would you do?
As I said, I will call for, because I cannot act just like that. I have to be also very careful. I will call for the file for sure and find out, get an officer for me, because I'm an extremely busy man. I may not be able to read all the papers. And then somebody comes out with a position, tells me what exactly is happening and what it should, and what I should do.
But prima facie,
what may be the one who needs to be done, once I do that, then I would immediately instruct the Executive Secretary to hold any further dealings in this property. That would be my first reaction.
but prima facie, we can all agree there is a problem.
There must be.
On the face of the record that we have, there is a problem.
There is a problem for sure.
And the problem is not just a product of our human nature, but also the way that office called Custodian Board is run. Incidentally, how many people work in that office? Are there more than 3?
They are different more than 3. Because I've got 3 members of the diversity committee.
Are they employees, full-time employees of the board?
No, they don't work every day, but they definitely are doing some work there. Then you have got Visible, I think he has got a personal secretary, and other officers. Unfortunately, I've not been there, so I cannot be very categorical to say the number is this.
Okay, the evidence that we have is that there is the Executive Secretary, Mr. Visible, and there is a secretary, as in the receptionist and the one who sorts out documents, and I think a driver. That is your board, that is your Custodian Board, Honorary Minister. That's it.
Yes, that is deliberate.
And
I'm part of that. That is deliberate because I wanted to have a very thin personnel. This is a temporary arrangement, as I've told you. It's a temporary arrangement to prepare us to wind up.
But Honorable Minister, do you think one individual can do this work, temporary or not?
Well, I've told you that.
You know, when you want to be so clean to the point of throwing out the baby with the bathwater, it's a matter of concern. The fact is, one person cannot do the job. That's why you have this person sitting, making terrible decisions. There's no control.
No, there is the diversity committee for sure, as I told you, which is composed of 2 people. I have 3 people now, as I speak. As I said, we didn't want to have a structure which is rather big. He came with a proposal and we refused it at the board because we want him to concentrate on winding up. And
You are going to kill the man.
well, he accepted it, so I thought that he would be able to execute this job. He has not come to complain to us to say that the job is too much for him.
I wouldn't complain if I was left alone to roam. Okay.
No, if you are a good officer and you want to do a good job, you come and complain to your boss when you have not been given.
Now the question is whether he's a good officer, and we'll get to that shortly. So,
Council, don't you think this is a good time for us to take a break?
Yes, my lord.
I think let's have a health break,
Yeah.
and then we'll return. And
much obliged, my
All
lord.
right, much obliged.